Good morning, Your Honors. The matter before the court this morning is the case entitled State of Vermont versus Denzel Lafayette, docket number 23 AP 106. Representing the appellant, Denzel Lafayette, is attorney Allison N. Fulcher. Representing the appellee, State of Vermont, is attorney Evan Meenan.
Thank you, and good morning again. We'll hear from counsel for the appellant. Please introduce yourself, identify your client, and then proceed.
Good morning, Your Honors. This is Allison Fulcher, and I represent Denzel Lafayette.
Thank you.
We raised 4 arguments in our brief. The state conceded that the matter should be remanded to correct the probation conditions for the reasons that we argued, so I won't be discussing that unless the court has questions. And also in argument 1, I believe is fairly straightforward, and again, unless the court has any questions, I won't be addressing that today. So I'm going to concentrate on arguments 2 and 3. And the question is whether the state's evidence was sufficient to prove the crime of carrying a weapon while committing a felony, in this case, the sexual assault. The controlling case is State v. Carter, which is a 1991 burglary case. And in that case, the court recognized that the legislature did not intend to penalize someone who happens to have a gun in his possession when he commits an entirely unrelated crime. Yeah. So here, there has to be a relationship between Mr. Lafayette carrying a gun and the sexual assault.
Counsel, can I interrupt you there? What can you tell us what happened to the gun after the appellant climbed through the window?
There was no evidence one way or the other what happened with the gun. When he climbed in the window, he asked KV if she would hold it for him. Right. And she refused. And the reason she refused is not because she was afraid of it. She didn't want her fingerprints on it. So once he climbed in the window, obviously he had it then, but we don't know what happened to the gun afterwards.
Oh, that's a question I was going to ask in follow-up, counsel, is did he have it when he climbed through the window or did he set it down outside?
Again,
so does it make any difference?
There's no evidence to what happened to the gun after he asked her to hold it and she refused to.
What about later when he refused to leave?
Again,
any evidence about that?
No, there's no evidence as to what happened with the gun. The neighbor testified that he saw him after, and he told the neighbor that he was hot, and the neighbor took that to understand that meant he was carrying a gun. But again, that other than that, what he was thinking, that was meant by that, there was no evidence to suggest necessarily that Mr. Lafayette still had the gun on his possession.
But he did take the gun. Go ahead. Go ahead. But he did take the gun into the room, correct? He had the gun in the room, and the victim said she did not want to touch it because she didn't want her prints on it. So it was in the room.
We don't know that because as he was climbing in or about to climb into the window, he asked her to hold the gun for him, presumably, because from what we've seen in the past, he carried it, in his waist inside his, his pants, and he couldn't climb in the window with the gun situated as such.
And when he asked her if she would take the gun, he was still outside, correct?
Correct.
All right.
Correct.
We don't know what happened to the gun after she said, I don't want to hold it.
Absolutely correct. There's absolutely no evidence about the gun after that.
And does it make a difference in terms of whether he possessed it at the time of the sexual assault, if he left it outside?
Yeah, the crime requires that you be in possession of the gun at the time you're committing the crime, and in this case, a sexual assault. So it had to be on this person, or which could have been in his hand. It could, but he had to be in possession of it, and we have no evidence to support that he had it in his possession at the time.
But he made it very clear from the onset that he did have a gun, a pistol.
Well, because when he tried to climb in the window, he asked her to hold it for him. So yes, he had a gun. And then there was the short video that was shown to the jury where in the past when he was communicating with KV that he has a gun and he carries it in his waistband. But again, this was not you know, there's nothing to suggest this was used intimidation to commit this crime. In fact, you know, if we look at all the evidence, it was clear that although KV couldn't consent because she was a minor, she wanted to have sex with Mr. Lafayette. This was not a crime that, you know, that gun played any role in facilitating the sexual assault.
Does it make a difference that it has the potential to do that, though? That it has the potential to put her under duress and then be forced to have sexual contact with the defendant?
Well, the problem with that argument is then you're saying that anytime somebody's carrying a gun, he's going to be guilty of the crime of, you know, when he's committing a sexual assault, that he's going to be committing the crime, you know, enunciated under 13 VSA 4005. And I don't think this court or the legislature intended for that to be the case. It has to be, and that's because, as this court said in Carter, there has to be a relationship between the two. It can't just be by default every time a sexual assault occurs. If the person happens to have a gun, that it's, you know, it's patent, as the court found in the burglary case in Carter.
Does it make
Let
a
me ask
difference?
the
Go ahead.
question. Go ahead.
Okay, now does it make a difference that this is the first sexual encounter between the two of them? Versus somebody who had a long-term relationship and the person happened to carry a gun versus the clawing through the window and having the gun?
I don't think that would make a difference. I think you have to find a relationship. And if a relationship, you know, was created, perhaps, you know, that they had sex more than one time, and, you know, he had carried a gun, and she always felt like she couldn't refuse if he had the gun on him, if there was something. But again, I don't know that it matters, you know, first or several times, but there has to be a relationship.
Let me ask a question in a slightly different way. I think I know the answer, but I want to be clear. When the first act of the sexual assault took place, where was the gun?
Again, we don't know. We have no evidence that it was on his person or in his possession at the time.
Well, we know that he carried a gun and that it was his habit to have a gun with him always, it sounds like.
Correct. He carried it, from what we could see, he tended to carry it in his waistband. And I gather that the way he carried it would be difficult to commit the act of sexual assault with it being on his possession, as we know him to have carried it.
And so, Ms. Fulcher, couldn't the jury reasonably infer that because of his history of carrying a gun, his showing it to her and her refusing to hold it, that he brought it into the room nonetheless? Isn't that a reasonable inference?
We don't have any evidence what happened. And even if he had it with him in the room, you know, he could have laid it down on a desk, not near the bed at the time. I don't think that necessarily establishes a relationship that it in any way facilitated or had the potential. She knew he carried a gun, and when he came to the window again, she refused to you know, she wasn't afraid of it. She didn't want her fingerprints on it. She didn't know if this, you know, gun was going to be found to have been part of a crime in the future. She didn't want any part of it. This gun had no relationship in this case, other than Mr. Lafayette was, you know, carried it. He showed it in the past that he carried it, but it had no bearing, no relationship to the sexual assault. And then, so that leads to the final argument on this issue, and that is the jury instruction. And in this case, it's plain error because the defense didn't ask for the instruction. But if we look at Carter and the court saying there was no plain error in that case because there was this relationship. That relationship the court found in a burglary in that case was patent. And again, as we argue, it's not patent in this case. Certainly, a gun can, you know, facilitate a sexual assault, but clearly the facts of this case not only did we don't know whether he had it in his possession at the time, but there simply was no relationship that did not facilitate the sexual assault. And so had the instruction been given to the jury in this case, the outcome certainly would have been different. So, we would argue that that there was no evidence that it was on his possession. There was no relationship between the gun and the sexual act, and the failure of the court to instruct the jury that, that the relationship had to exist, lends this conviction to be reversed. And if I don't have any further questions, I would ask this court to please, for the arguments raised today and in the brief, to reverse Mr. Lafayette's convictions.
All right, thank you very much. We'll hear from counsel for the appellee. Please introduce yourself, identify your client, and then proceed.
Good morning, and may it please the court. My name is Evan Meenan, and I represent the state of Vermont. As did the appellant, I'm going to move first to the firearm conviction in this case. And this court is very familiar with the standard, but the standard is deferential to the role of the jury. And this court has recognized that a motion for a judgment of acquittal, which is what is being appealed, should only be granted when there is no evidence to support a guilty verdict. The only element that the appellant challenges on appeal is whether or not there was a sufficient relationship between the gun he was carrying while during the sexual assault of KV and then the sexual assault itself. Both parties in this case rely on the Carter case, and there's a few really important statements from this court in that decision.
Okay, before you get to those, counsel, let me ask you this. Where is the evidence that he had the gun in his possession when the sexual assault took place?
Well, I have to apologize on this point, Your Honor, because I am pinch hitting for Alex Burke, and I've been sick for the past several days. So my level of familiarity with the record on this in this particular appeal is not what it would normally be. And so I'm not in a position to necessarily disagree with appellant's characterization of the evidence. What we have is the video evidence of the appellant displaying the gun to the victim prior to the assault. We have the defendant bringing the gun to the victim's window and immediately before climbing into that window, displaying it to her and asking her if she would hold it. And then we have evidence after the assault took place that he informed a neighbor that he was, quote, hot. And based on the nature of that exchange, the neighbor concluded that the individual possessed the firearm.
Okay, so let me run a scenario by you. He has shown her this gun in a previous time, comes to the window that evening, asks her, will you hold this gun while he's standing outside? She says no. He sets the gun down outside the trailer, goes through the window, has sex, comes back out, picks the gun up, and takes off when he encounters the neighbor, and he says that he's hot. Would that be enough for a conviction on this in your mind?
Yes, it would. And this is where I think some of the both the standard and the quotations from the Carter decision are really important. What this court said in Carter was that there must be a quote, a relationship between the carrying of a weapon and the underlying felony. However, this court said that the state does not have to prove, quote, an element of scienter. It doesn't have to prove, quote, that the weapon was used or brandished, end quote. And in this case, it was certainly displayed. And this court even stated that the state does not have to prove, quote, that the defendant knowingly carried the weapon, end quote.
But they do have to prove that he carried it when he committed the assault.
Well, it depends upon how you define when he committed the assault. In other words, does he actually have to be holding it in his hand while engaging in the sex act itself? The state's position is no, that it does not. And then that is because of the last important quote from Carter. And that quote is, "It is enough that the weapon had the potential of facilitating the commission of the underlying felony." And what happened in Carter was that this court held that, quote, that a weapon has the potential of facilitating the felony of burglary is patent. And that phrasing is really important. It wasn't talking about that particular burglary. It was talking about the felony of burglary. And the state's position is that it's true, that same patent conclusion is true with regard to sexual assault. We disagree with the appellant's characterization, however, that this somehow means anytime you carry a gun, you're automatically convicted of this offense when you commit another felony. For example, the easiest category of felonies to identify would be many felonies that are committed outside the presence of a victim. That could include things like the online dissemination of child pornography, subsequent DUIs where the gun is just present in the vehicle, or, for example, certain financial crimes such as embezzlement when the victim has placed the funds voluntarily in the defendant's care. Here,
let me ask you another hypothetical, if I might. I'm sorry to interrupt. Scenario, he has a gun in the car, drives up, gets out, comes over to the window, goes in, has sex, goes back out, leaves. He says to the victim, "Oh, by the way, I have a gun in the car. Would you like to see it?" Is the gun in his possession then when he commits the crime?
I think that based on that particular fact pattern, that I think is a much closer call than in this particular case, but that's not the fact pattern here, because we have information that the defendant actually displayed the weapon to the victim. Now, appellant is placing a lot of emphasis on the fact that the victim was not afraid of the gun. However, it's the state's position that based on the facts that we do have, a jury could have reasonably inferred a couple of very important things. First, the jury could have inferred that the defendant brought the weapon in order to coerce KV to engage in sex if she had a change of heart, which it appears she did not have a change of heart. He could have carried the weapon to ward off individuals who may have had a problem with the fact that he was there to sexually assault her, or he could have used the firearm to facilitate his escape if he was caught while engaging in the sex act. And that's why the comment to the neighbor is really important. When he told the neighbor that he was hot, I mean, he was on the way out of this property after sexually assaulting KV, and the first person that he encounters, he informs he has a firearm. And so it's the state's position that that's a really important fact, and that the jury could include, based on that fact alone, that the defendant possessed the firearm in this particular case because he was concerned that he might need it in order to commit the crime or flee the scene after committing the crime. And again, the standard in this particular case is highly deferential to the jury, and it's the state's position that this court should not overturn the jury's guilty verdict. Turning to the issue of the jury instructions, the state agrees that the appellant did not object, and then therefore the applicable standard is one of plain error. And again, both parties rely on the Carter decision. And in that case, this court affirmed the conviction when the trial court instructed the jury that it had to find beyond a reasonable doubt, quote, that the defendant carried a weapon while that burglary was being committed. The jury instructions in this particular case are similar to those in Carter, if not better. And that is because the court instructed the jury that the third essential element was that the appellant, quote, carried the dangerous or deadly weapon while committing the crime. That is very, very similar to the instruction in Carter. And it also instructed the jury two other really important facts. The first of which is that if it found him not guilty of the sexual assault, it had to find him not guilty of the firearms charge. And then also, this is perhaps the most important instruction that it provided, quote, all of the elements of the offense must have been present at the same time. If the state has not proven each of the essential elements of the charge beyond a reasonable doubt, then you must find Mr. Lafayette not guilty. Based on that instruction and the presumption that juries follow instructions, the jury must have inferred that the defendant was carrying the firearm while committing the offense. And so that relates to a lot of the hypothetical questions and the questions about the evidence that this court asked appellant and what we did and did not know about where the gun was during the actual sex act that took place. And based on that instruction and the presumption that juries follow those instructions, it must have inferred based on the fact that he had the weapon before he entered the room, he had the weapon after he left the property and was confronted by the neighbor, that he was carrying the weapon while committing the sex act. With my time remaining, I would like to talk briefly about the sexual assault conviction, even though appellant did not visit that during its principal argument.
Is that the sufficiency of the evidence issue, the first issue in the case?
Yes, it is. And so again, the standard is pretty much the same, viewing the evidence in the light most favorable to the state and excluding modifying evidence. Was it sufficient to support appellant's conviction for engaging in this sex act? And again, by statute, the definition of sex act means conduct between persons consisting of contact between the penis and the vulva. That's the applicable portion of the definition as I understand it. And in this case, KV's mother testified that the appellant admitted to her that he had sex with KV and he was in the wrong for doing so. And KV testified that the appellant, quote, had sex, and specifically that he put his penis in her vagina. As a biological fact.
But the testimony was a question and she just said yes. She didn't actually say the words. I think that's what the argument of the appellant is, that she didn't actually say the words. The words were said by the prosecutor.
Well, sure, but there's no allegation that KV was somehow KV's capacity to answer a straightforward yes or no question was somehow diminished to the point that her agreement is not reliable. And the jury, as the trier of fact, was certainly able to make that determination and either accept or reject her testimony. It's clear that it accepted her testimony when she agreed with the fact that the defendant put his penis inside her vagina. And as a biological fact, it's impossible to do that unless the penis makes contact with the vagina. And thus, in this case, the evidence was more than sufficient under the standard to affirm appellant's conviction for sexual assault. With my time remaining, I might as well address the last issue on appeal and simply agree with the appellant that in its brief, the state agreed that a remand was appropriate to address the probation conditions, specifically condition 13 and 34. The state has agreed that additional findings are necessary. And I believe that the state agreed that condition 112, I didn't know we had 112 probation conditions prior to this argument, so you learn something every day. But the state agreed that a clerical error was made, and that condition should be restricted to females. So thank you very much.
Mr. Meenan, can we do that? Can we just make that order and direct the court to remove the language about males, or does it require findings below?
I think since the parties have stipulated, this court can direct the court to issue a revised condition 112. However, if this court was uncomfortable doing that, I don't anticipate that there would all of a sudden be a disagreement in the case upon remand. Since there's going to be a remand anyway, I'm confident that this issue will be taken care of. But I don't think that the state would object to the court directing the trial court to correct condition 112 as part, and then the trial court would issue a new probation order. I think that would certainly be an acceptable way of moving forward.
Thank you.
Thank you very much.
Okay, thank you, counsel. Does the appellant have time?
Appellant has 4 minutes and 47 seconds remaining.
All right, counsel.
Well, I think that there's a real problem with the state's argument, and basically by saying, you know, the relationship with a burglary is patent, and the same goes for sexual assaults, that the state's basically saying that there are certain crimes that no matter, you know, what the circumstances are, what the facts are, that automatically there's this relationship and you're going to be guilty of 13 VSA 4005 if you're carrying a gun. So every time you carry a gun, you know, during a burglary, you're automatically, you know, guilty of this crime. And they're saying the same for sexual assault, and that's simply not the case. You have to find a relationship. And I would say, you know, if you look at a burglary, you don't call the person up before, you don't communicate with them, say, hey, I'm going to be breaking into your house tonight.
She's broken up on my.
Yeah, you're kind of breaking up. Maybe turn your video off.
and this,
You're breaking up. We can't hear you.
assault, if he, the victim is.
Attorney Fulcher, your voice is breaking up. Can you turn your video off? Can we turn her video off? Petra?
I just tried. We'll see what happens
Oh,
here.
yeah.
Like we have lost.
Can you let her know that the video, that her voice is not coming through?
Yes, I will.
Okay.
We lost the timing as well, Chief.
Yeah, please. That's, I was just going to say, thanks. Thanks, Attorney Lydon. As of yesterday.
Wait, I'm gonna correct the record on that, Chief. He was sworn in before.
I swore him in.
Oh, well, is that right? Oh,
But he wanted you to officially do it, Chief.
well, that's right. He... Any news, Petra?
Attorney Fulcher, are you able to hear us?
Okay.
Oh.
So how about if she phones in?
I think I'm back now.
Oh, there you are. Yeah, yeah, good.
I'm not sure
Please
what happened. We have since the storm. We have been having problems with our internet, so that may be the case.
Yeah, I hear you. Yeah. Okay.
Uh,
Please go ahead.
Okay. Well, what I was saying is that it's not, the legislature did not intend for this to be an automatic crime. That somebody who is carrying a gun during certain crimes automatically is guilty. You still have to go through steps. You still have to find, most importantly, that there's a relationship. And it, like I was saying,
Ms. Fulcher, I'm sorry to interrupt you. And can the jury make reasonable inference regarding the facts and circumstances of each specific case to make a determination whether or not the gun was or a weapon was used as part of the offense?
Sure, but that would
Combination of many different events, such as then a jury could infer that that's being used as part of the offense.
Yeah, I mean, sure, but I mean, again, there has to be that relationship, and that's the problem in this case, is that instruction wasn't given to the jury. So the jury in this case didn't have to find that there was any relationship, that the gun in some way, had the potential to facilitate this. That relationship instruction was never given to the jury, so they didn't have to. All they, that's a key piece in this case.
But Ms. Fulcher, we said in Carter, didn't we, that there is no plain error for that exact reason if we find that it met the standards of Carter, which is it could have facilitated or had the potential of facilitating the commission of a felony. So if we make that finding, plain error isn't found, right, under Carter?
Right, but I don't know. I don't know how you can find that that there that you can't, that it's patent, a sexual assault, that carrying a gun is patent without every time. Then I can't think of a scenario on this court is then saying that every time that there's.
So let me ask you this. Sorry for interrupting, but I think I knew what you were going to say. So give me an example of a felony during which a person has a firearm on their body but doesn't brandish it, where there is a relationship between carrying the gun and the felony.
I would say what I was trying to argue before is burglary. I think is one of those crimes where it's going to be very difficult to show that it doesn't have the potential. Again, you don't call somebody up before and say, "Hey, I'm coming over to your house tonight, to burglarize her house. So in those situations, when you're carrying a gun, you know, it's one of the, you know, it's a surprise, you know, they have no idea. So that fact that you're carrying a gun has the potential to, you know, to help you with that crime. You know, if you encounter somebody unexpectedly, then you have that gun to intimidate that person at that time. In this case, the sexual assault was going to occur whether or not he had a gun. There was,
Well, I mean, I don't know that that evidence is in the record, because someone can always say no, even if they've previously said yes.
right, but then you're going back to the argument that every time a gun is present during a sexual assault, that the person is guilty of committing it, and then the relationship goes out the door, because then now we have a whole series of crime where it's just patent. And I think in this case, it clearly shows you why that you can't make that argument in a sexual assault, because there's nothing to suggest that she would have changed her mind, you know.
Let me make this point so the record is clear. This is a minor we're talking about.
Correct.
Consent is not an issue in this case.
That's correct.
Yeah. So I just like the record to be clear about that.
That's correct. I mean, if he had forced himself upon her, or you know, she allowed it to happen, as was the evidence probably in this case, the gun had really, you know, the sexual assault was he was going to be guilty of sexual assault one way or the other, whether he had the gun or not. The question is whether we can tack on this additional crime simply because he had a gun when he, and again, we argue that we don't know that he had it on his possession. We have no evidence to support that he had it on his possession at the time. So that's a problem with the conviction too. But also in this case, you know, even if he had it on his possession at the time, there's nothing patent in this case that had the potential. You know, of course it had the potential. It always has the potential, but you can't disregard the requirements of the relationship.
Okay. I think your time has expired. Thank you very much. Please call a conclusion of the hearing.